You know what a preliminary hearing is?
No, why don't you explain?
Okay. By the way, I'm on video now.
Okay,
Um,
cool.
so now I see you. That's a background behind you, right?
Yes, sir.
Yeah, you're not in the woods, but it
No,
looks
no,
nice.
no.
Okay. So everyone knows you have the right to a jury trial in California, right? 12 members of the community come in. The standard of proof is very high. It's called proof beyond a reasonable doubt. Prosecutor has to prove each and every element of each offense to that standard. The jury gets the case, they deliberate, not guilty or guilty. Well, before you have to go all the way to a jury trial for a felony, you have the right to a preliminary hearing. A preliminary hearing is no jury, just the judge. The standard of proof is very low. It's called probable cause. And the prosecutor does not have to put on all of their evidence for the preliminary hearing. They just have to show enough for the case to move forward to trial. The prosecutor does not need to call all of their civilian witnesses. So, as I said at our preliminary hearing, none of the alleged victims testified. And that's based upon a rule of evidence that we call Proposition 115. And Proposition 115 allows a police officer who's either post certified or has 5 years of law enforcement experience to testify to what we call one layer of hearsay. So that's what we had at
Oh,
the preliminary hearing.
got it. Got it. So, in other words, but in this type of proceeding, there's an implicature there, right? You've already talked about um, a security guard not being particularly credible. You've talked
Right.
about other individuals being provocateurs, which is common whenever you don't agree with a political point. And then it's also understood that some of these people can be somehow connected to law enforcement. Um, all of this is to say that if in that preliminary hearing the evidence seems flimsy, why even take it further for an actual jury trial? Why is the standard so low?
That's what the law is on a
Mm.
preliminary hearing. And I'll just give you, if I tell you the alternative charging mechanism, then it might make sense to you how the preliminary hearing standard is so low. So the alternate uh, method of charging someone is called an indictment. And the way an indictment works is there are no defense attorneys, it's just the prosecutor, and it's called the grand jury. So 24, 28 members of the community sit, and the grand jury is convened, and the prosecutor presents the same evidence that they could at a preliminary hearing, but just not to the judge. So for prosecutors, the advantage of the indictment is that it's a private proceeding. So it's a secret proceeding. And then
Mhm.
what happens is you get indicted, and then your next procedural event is a trial. So the
Got it.
preliminary hearing is a public hearing. It's not to a jury, it's not to a grand jury, it's to the judge. And the standard of proof is low because it's designed to eliminate or filter out charges which have virtually no evidence.
Mm. Okay,
So it's kind of like a gatekeeper function.
got it. And then
But
hence
we
that.
use it to figure out the prosecution's theory of the case. We can lock witnesses in to particular testimony, which we have done in this case.
Wow. Could you elaborate on that? Which witness have you locked down? Is it on in favor of Alex
Well,
or
yeah,
questioned
we've
you?
locked in a lot of amazing, I think, significant and amazing points. And Judge Wilkinson alluded to one of them. So going back to John Doe number 2, the allegation was that pursuant to this, having him get out of the car, which he did voluntarily, uh, he got out of the car because he thought he was going to get beat up. And he said, "What can I do not to get my ass beat?" I believe that's what he said. But he got down and he knelt down. And prior to that, the detective said that Alex said, "If you don't apologize, I'm going to beat you every day." Later in the hearing, the detective admitted that it could have been, if you don't apologize, I'm going to be here every day. And that's a significant difference. So we lock the detective in on that. That means at trial, if he goes and says, well, I know he said, I'm going to beat you every day, then we'll bring up his prior testimony. And then the jury will say, huh,
Got it.
why isn't he saying what he said before? And that is a witness credibility issue.